Thank you all so very much. That's it. Thank you. Good afternoon, and very special welcome. Welcome in particular to all of the wonderful, wonderful students who are here today with us. And by the way, by students, I include every single one of you here today. I want to begin by introducing my closest companions in what I call lawyer heaven. And I'll start with the judges of the Court of Appeals seated immediately to my left. Judge Carmen Siparik, Judge Victoria Graffio, Judge Robert Smith, Judge Eugene Piggott, Judge Theodore Jones, and my colleagues of the Administrative Board of the Unified Court System, seated immediately to my right, the Presiding Justice of the First Department, Jonathan Lippman, Presiding Justice of the Second Department, Gail Prudenti, Presiding Justice of the Third Department, Anthony Cardona, Chief Administrative Judge Ann Pfau, and I'm so sorry that Judge Reed and Judge Scudder were unable to be with us today. Yes, special round of applause for them too. As I have contemplated this day, my final State of the Judiciary, the words swan song drift to mind, not at all in a morbid sense, but simply as a significant closing chapter. Indeed, the dictionary defines swan song as a poetic, musical, or artistic work composed shortly before the end of an artistic period. And while I do not view my words as poetic or musical, I think we can all agree that there is a certain art and artistry in what all of us do in the courts, don't we? Hence, this theater setting on the campus of my alma mater, New York University, and a swan song. Right at the outset, you should know that there are two themes that you will not hear today. First, I intend to address you in my role as Chief Judge, not in the other role that saddens and sickens me, Chief Plaintiff. It is heartbreaking and frustrating and demoralizing beyond description that our judiciary, our proud judiciary, alone among judges throughout the entire nation, alone among New York State's roughly 200,000 full-time employees, should have had its compensation frozen for more than a decade, despite our persistent efforts with 3 successive governors and legislators who have acknowledged that the judges should indeed have the increases they seek, yet nothing happens. I will leave that subject for another day and another forum, and I'm so delighted that my lawyer is here today at my side, too. Another close companion in what is not necessarily lawyer heaven. This continuing misery, of course, is the reason I delayed delivering the State of the Judiciary in the beginning of the year, as is our tradition, but I didn't want the year 2008 to pass without our usual report. The second subject I will not address today is the question I am most often asked: what next for you? As you can imagine, having had the role of a lifetime for more than 15, no more than 25 years, that too is a very unhappy subject for me. Nor is it my mindset. As I have watched the remaining days of my term dwindle, my thoughts have been not what's next, but rather what more can we accomplish in the courts these next precious 49 days, so beware. And that is the course I intend to follow in this final State of the Judiciary, not to talk about what's been done, though some of that, of course, is inevitable, but rather to focus on our newest efforts, on important unfinished business, on the state or condition of the judiciary I will hand to my successor. How do I accurately and adequately report on one of the busiest court systems in the entire nation, each year handling millions of cases of every variety, impacting the lives of litigants, impacting the law that governs our society? What you will hear about today is not decisions in particular cases, which is the core of what judges do, but rather initiatives to help the court system do its work better, essentially initiatives to help us deal better with the flood of frustrating social problems that are every day deposited at our doorstep. My plan is to start with a brief overview of family, civil, and criminal dockets, and then to highlight several initiatives that transcend these particular categories. At the conclusion of my remarks, those of you who are still awake, and I'll be watching, you all can sit immediately for the New York State Bar examination. And by the way, there will be a printed version available, which is about twice the length of what I will deliver orally. I thought it would have been cruel and unusual punishment to make you sit through the whole Megillah today, but I do hope you'll read the entire document. I begin, as in past years, with family justice. That's a subject dear to my heart. First family court, and then matrimonial litigation. As many of you know, I arrived on the state's high court directly from a commercial trial practice, but I stand before you a quarter century later convinced beyond all else that we must summon our resources and our efforts to help the children in our family courts. And for each of us, this exercise is not at all an unselfish one. It's their future, of course, but it's our future, and it's our nation's future, too. For those of you unfamiliar with family court, you should know that new case filings topped 700,000 in the year 2007. We're projected to hit 700,000, 728,000, and heading northward, skyward, for the year 2008. These are demanding cases involving child abuse, foster care, termination of parental rights, juvenile delinquency, and the like. What's more, in the past year, abuse and neglect filings are through the roof. They've more than doubled in New York City alone, as are the court appearances mandated by recent state and federal legislation. Now, we have a total of 149 full-time family court judges, 47 of them in New York City, 149 judges, 728,000 plus cases, more than 2 million court appearances a year. You do the math. I personally have never before seen such burdens placed on family court, emotional burdens, calendar burdens, typically necessitating long court days and long court delays, delays that in child time are an utter eternity. No fair to the litigants, no fair to the courts. So first and foremost, even in these dark and difficult days, we must renew our request for more family court judges, especially in New York City, and don't you all agree? Additionally, to help address the critical situation in New York City Family Court, we have now embarked on an unprecedented new collaboration, an intensive, fast-tracked effort to reorganize and improve the handling of child welfare proceedings there. We have brought together our administrative and supervising judges with representatives of the New York City Administration for Children's Services, the Mayor's Office, the Council of Family and Child Caring Agencies, foster care agencies, assigned counsel panels, and providers of counsel for parents and children. And what has emerged is truly a stunning new program being implemented even as I speak that is designed to achieve continuous trials, yes, as close to day-to-day trials in family court as humanly possible in present circumstances, as well as fewer and shorter adjournments. Our joint objective, our fervent hope and belief is that these measures will accelerate the time to disposition and early permanency for children. This genuinely outstanding joint effort holds enormous promise, and I thank and congratulate every one of the participants for their their enthusiastic, cooperative spirit. Yes, this can be done. Yes, it will be done. Now, vital as judicial independence is in our decision-making, plainly collaborations are essential to court operations, as this new initiative shows. And the subject of collaboration leads me naturally to our permanent Judicial Commission on Justice for Children, a multidisciplinary model, I'm pleased to say, that has been replicated around the nation. At its inception, the Commission centered its efforts on the youngest children, 0 to 3, who are before our courts, promoting early intervention, the healthy development of children in foster care, the needs of infants involved in child welfare proceedings, and establishing a statewide network of children's centers in the courts. I'm proud to say that we now have 34 children's centers spread all over the state of New York, offering a safe place for children to linger while their caregivers tend to court business. Last year alone, we had more than 55,000 visits to our children's centers, and we made nearly 7,000 referrals to essential state and federal services like Head Start and early intervention. And thanks to private donations and the federal program Reading is Fundamental, every single child leaves our center with a gift of a brand new book. Now, the Commission's latest initiative is to encourage youth, and here I'm speaking especially of older youth, adolescents, to participate in their court permanency hearings. This reflects a huge shift in thinking from efforts to shield young people from court proceedings to a recognition that, yes, it is desirable for us to listen to them and speak to them directly when there is a major change about to take place in their lives. The Commission has worked with the Office of Children and Family Services, the Court Improvement Project, and Youth in Progress to develop a DVD that underscores the value of youth participation. It's produced an excellent handbook to help judges maximize these opportunities, and it has actually designed a supervised courthouse waiting room, which we call Teen Space, and I can tell you it's pretty nifty, with age-appropriate resources for teenagers when they come to court. Our very first Teen Space opens next Tuesday, November 18, in Queens County Family Court. I will be looking for all of you to be there. Now, just a final word on one additional collaboration in the family court area. 5 years ago, we launched what we call Adoption Now to find new ways, together with the city and state, to eliminate needless systemic barriers and expedite permanency for children. Tremendously, tremendously important. These continuing collaborations have helped us reduce the number of free children awaiting adoption in New York State by nearly 50%, from 6,068 children to 3,407 children. Not enough of a reduction, I agree, and still a subject for some very hard work. Now, still in the family justice area, I want to turn next to the subject of matrimonial litigation. Vexing as this subject is for the courts, the impact falls far, far harder on the litigants. Much too much delay, much too much expense, much too much agony for families and children. And here I have a unique personal perspective, because before becoming Chief Judge back in 1993, I sat on a commission to study matrimonial litigation that traveled the entire state of New York to see and to hear the problems firsthand, and ultimately evolved what became the matrimonial rules. Unquestionably a step forward, again, not enough. Indeed, in the years since, as society changes, it may well be that matrimonial cases have become, if this is possible, even more challenging and more complicated, personal and sophisticated issues. My report, however, is not simply dour and negative, as of course it could be. Instead, I've looked hard and chosen instead to center on what's positive and innovative and a search for new and better ways to use the resources that we have. And here, I take my hat off to the statewide administrative judge for matrimonial matters this past decade. Where are you? Jackie Silberman. Congratulations to you. And to your, oh my goodness, this isn't Joe the plumber, is it? And let me count the ways, or just a few of them. Social workers to assist families in custody, visitation, and relocation disputes. The Children Come First program with trained mental health professionals to conduct early screening and assess the level of family conflict. Parenting plans that foster sensible agreement between parents. First-rate educational seminars for judges and lawyers handling matrimonial cases. New legislation with thanks to the matrimonial bar and to the legislature. A pro bono initiative for litigants who can't afford counsel, and on and on and on. On the subject of matrimonials, I've saved for last, and a bit more particularity, the subject of alternative dispute resolution, mediation. Now, mediation was a downright dirty word in family litigation a couple of years ago, and understandably so, given fears about potential unfairness to the more vulnerable parties, such as domestic violence victims and non-moneyed spouses. Today, several divorce mediation programs have been successfully launched, or very soon will be, in New York, Nassau, Erie, Suffolk, Orange, and Queens counties. Innovative ADR programs, such as parenting coordination for high-conflict disputes, have been developed in Nassau and Erie counties, and still we soon hope to open our New York City Collaborative Family Law Center, designed to further limit the trauma associated with divorce. All told, very promising prospects in what remains a uniquely distressing area of the law for the courts of the state of New York, and especially for the people we serve. Now, the same spirit of collaboration and innovation carries over to our civil dockets, and they account for nearly 1.8 million new filings a year. Pretty astounding, don't you agree? And here again, the range of issues we see in the New York State courts absolutely defies description, from a slip and fall on an icy sidewalk to a global business disaster. I've chosen today to illustrate this segment of our operations through a single slice of life, from the housing court of the City of New York to our foreclosure initiative to our commercial division. All caseloads I just know are going to mushroom given the state of the economy. Now, obviously, we could spend days discussing the vast array of other civil matters in the New York State courts. Some things you just never forget, and one of them is a visit I made very early in my tenure as Chief Judge to the housing part of the Civil Court of the City of New York, which was at 141 Livingston Street in Brooklyn. Unforgettable. Someone told me this compared to a Calcutta bazaar. Now, I've never visited Calcutta, but I got the message right away. Aimless crowds of needy people in very shabby surroundings. So a decade or more ago, we launched our three-part housing initiative: effective case management, specialized parts, improved access for litigants, and here I am especially grateful to our administrative judge for the Civil Court of the City of New York, Fern Fisher. Thankfully, in 1997, the legislature increased the number of housing judges from 40 to 50. Case dockets at that time averaged only about 329,000 a year and rising, and again, try doing the math. And we added court attorneys, we added resource assistants to help gather information and resolve issues. In an area of needy people faced with evictions from their homes or disrepair that threatened life and limb, even the development of housing court forms, which are now in very wide use, has been tremendously beneficial. And at the same time, we actually professionalized the court, replacing massive calendar calls with direct assignments, scheduling appearances, introducing measures to bring landlord-tenant negotiations out from the resources of courthouse corridors and into the sunlight of the courtrooms. I think our specialized parts have been pretty helpful too, like our military part, for example, keyed to individuals called to military duty, and there have been innumerable programs to increase access to justice through our resource centers, through our videos, and through our publications. With so many unrepresented litigants in such consequential litigation, I especially applaud the volunteer efforts of the New York Bar, whether the City Bar Association Lawyer for a Day project or the Senior Citizen Council program co-sponsored by the City Department for the Aging, or the Housing Help program co-sponsored with United Way of New York City and the City Department of Homeless Services, or programs designed with Columbia Law School and other area law schools. The response of the bar has been very, very heartening in this vital area. And I say with fingers crossed that it will continue to be, because it just doesn't take a genius to see that there is an increasingly dismal picture ahead in this area, does it? And that brings me right to the door of our foreclosure initiative. A deeply, deeply troubling aspect of the dramatic upheaval in our economy has been the nationwide surge in residential mortgage foreclosure cases. You know, of course, that every single foreclosure requires a court order. Every single foreclosure comes through the courts. In New York, our courts are experiencing record-level foreclosure filings, a trend that will continue and undoubtedly worsen greatly in the coming months. In some counties like Queens and Suffolk, can you believe this? Filings have risen by 200% in the past few years. And you don't need me to tell you that foreclosures have a very far-reaching impact. Families displaced, neighborhoods devastated, the state's economy weakened. To address this crisis, last April, we announced a brand new program launched in Queens Supreme Court, and I thank you especially, Queens County Administrative Judge Jeremy Weinstein. The intent of this program is to assure that homeowners of 1 to 4 family dwellings who are facing foreclosure are aware of available lawyers and counselors who can help them avoid unnecessary foreclosures and reach out-of-court settlements. That would make very good sense. On the filing of a foreclosure action these days in Queens, the court system has been notifying homeowners of an opportunity to attend an early court conference, a very good idea. And as of September 1, when new statewide legislation went into effect, that kind of notice became a mandate in every foreclosure action involving high-cost subprime or non-traditional loans as defined by the legislature. Now, so far, the court system has sent about 25,000 notices to homeowners. And quite frankly, to tell you the truth, we've reached a new juncture in learning how best to respond to this crisis. Surely the conferences are a good idea, a great idea. And we are setting up dedicated foreclosure parts in courts all around the state, presided over by specially trained personnel and staffed by case managers who schedule the conferences and provide other support. Even if a settlement isn't reached, clearly a conference can assist the parties in arriving at a plan to streamline subsequent proceedings, promote active case management, and avoid unnecessary delays. And that would serve all New Yorkers by reducing hardship, cost, and neighborhood blight on our hardest-hit communities. But there's a huge difficulty. And the difficulty, of course, is one we encounter very frequently in the court system, and that is translating what is a good idea, a great idea, into a working reality. That is very hard. Obviously, receiving notice of a court conference, an opportunity to work out settlement with the lenders, is meaningful only if the borrower can take advantage of that opportunity. And in residential foreclosures, to date overwhelmingly ending in the borrower's default, there is a very large gap to fill between the offer of a court conference and the reality of a workout, a gap that requires the borrower to respond to the notice and the legal and financial communities to provide the borrower with the assistance that the borrower needs, most likely on a pro bono basis, and there lies the problem. Without this sort of free assistance for the borrower, the mandated conference just can't achieve its objective. Having over the past several months participated in many meetings regarding the mortgage foreclosure crisis, including efforts to assure that our mandated conferences will indeed meet their objective, I can predict with certainty that this is one problem I will be handing to my successor. This will not be resolved by December 31, 2008, and it is going to remain a very high priority for all of us, for the dedicated judges and staff focused on the effort, and for the great New York Bar, which has so many times come to the aid of needy people by providing free legal services. This is an urgent time to do so. Now, the third and final segment of the civil courts portion of my State of the Judiciary is not a cry for help for needy children or people in danger of being evicted from their apartments or losing their homes. It's rather a moment's reflection on an initiative that has reached maturity in pretty good shape, poised to assist New York State in another sort of litigation engendered by our flailing economy. And I refer here, of course, to the Commercial Division of the Supreme Court of the State of New York. The Commercial Division began back in 1993 with 4 specialized parts in Manhattan tasked with improving state court efficiency in the area of commercial cases. And I have to tell you, the response was Well, I was going to say the response was overwhelmingly positive, but I think after all these years, I have to say that's a real overstatement. I don't think there's been overwhelming response to anything that's positive. Nothing is without its critics, but within 2 years, with the help of its co-parent, the commercial and federal litigation section of the New York State Bar, the commercial division was born, and today, I'm pleased to say there are 22 parts operating successfully throughout the state. Aside from its own day-to-day contribution to the law and business in the state, the commercial division has produced benefits all across the state court system, relieving already overburdened civil dockets of typically complex, paper-heavy, pretrial-oriented case. It's been our technology laboratory piloting innovations like e-filing and online access to information for practitioners, and it has steadily enlarged the availability of ADR for litigants. I feel safe in saying, I feel good in saying that the commercial division offers business litigants a justice system commensurate with today and tomorrow's challenges, and commensurate with New York's status as a world financial capital. Now, after family and civil cases, the remaining 1.5 or more million new filings in our bustling court system fall into the area of criminal cases. Again, cases of every imaginable variety, from multiple murders to carrying an open beer bottle on the streets of New York City. Cases overwhelmingly driven by drugs, from a chain snatching to support a drug habit to major narcotics felonies. And here I intend to focus on what we call our problem-solving initiatives. But truth be told, everything that comes into our courts, every bit of time and talent of our extraordinary judges and staff involves a problem that needs to be solved. Our first venture into problem-solving justice was in 1993, the Midtown Community Court, smack in the middle of Manhattan up on West 54th Street, aimed at partnering with the neighborhood to address the sort of repeat low-level criminal conduct, often driven by drug addiction, that overfills our dockets, corrodes the quality of life for everybody, and sends the offender on a downward spiral of worsening, more threatening crime. We asked ourselves whether instead of brief jail time, or more often simply a sentence of time served, our court interventions could be more meaningful, genuinely more finally dispositive, whether we could take the opportunity to stop the deadly drumbeat of drugs, crime, jail, endlessly on and on, offenders going right from prison or jail for the brief time that they serve, right back to their same lawless behavior until their next court appearance, and in collaboration with the district attorneys and the police and the defense and agencies and service organizations, even with the neighborhood. The answer to that question became a resounding yes. Midtown was the first community court in the nation. Today, we have 8 community courts in the state of New York. There are dozens of community courts inspired by Midtown throughout the United States. There are even community courts today in Australia, in England, in Canada, in South Africa. I'm so pleased that Louise Casey, one of the Prime Minister's right hands, is here from London, conferring with us right now on Midtown, on community courts in England. Together with all of our collaborators, we have built carefully, very, very carefully, on the Midtown experience. So my focus today is going to be first on drug courts briefly, and second on domestic violence courts. And in both instances, they reflect 2 very frustrating societal problems, social problems that elude solution and inundate the courts. Since the opening of our first drug court in 1995, we have had more than 18,500 graduates. We have more than 7,000 participants currently in the program. And most wonderful of all, we've had 623 drug-free babies born to female drug court participants. Pretty impressive, don't you agree? Drug courts today are available all through the state of New York. And research tells us, absolutely convincingly, that drug court participants complete treatment at more than twice the rate of those who enter voluntarily, that the combination of judicial monitoring and drug treatment continues to have beneficial effects well after participants leave the criminal justice system, and that they are tremendously cost-saving for the court system and for the state, additionally, in avoiding the use of resources to retry and retry again the same people over and over and over. One California study concluded that drug courts save an average of $8,629 per participant compared to offenders whose cases are not in drug court. And if the dollar savings don't move you at all, if they don't persuade you of the value of this initiative, you all should pick up a copy of a little book. It's available outside, called Drug Courts, Personal Stories, to see firsthand how drug courts have rerouted the lives of people who were headed for absolute disaster. Now, domestic violence courts are my next example of effective use of court resources to address a societal problem that falls very heavily on the judicial branch. Soon after I became chief judge, I had a very powerful education in domestic violence and the courts. We had 2 murder-suicides. I don't know how many of you remember them. 2 murder-suicides. One was in Kings County, one was in Westchester County. And in each case, in each of those cases, the victim had actually obtained an order of protection, which she had in her pocket, but that proved absolutely insufficient protection against the intimate partner who murdered her. Today, the court system, today, all society, we've learned a great deal more about the modern-day scourge of domestic violence, haven't we? The challenge for us was to find an approach to domestic violence cases that recognized that they are different from cases involving violence between strangers. We needed an approach that stresses victim safety and offender accountability, an approach that fosters greater coordination with community stakeholders, an approach that allows litigants to resolve their disputes in an environment where services are accessible, an approach to the extent that is humanly possible that will avoid the next murder-suicide. And those became the guiding principles for the New York State domestic violence courts. We know there is still a great deal of work to be done because those troubled families have cases that go beyond the Supreme Court, that go into family court, criminal court, and more because of New York State's archaic and fragmented court structure. And so our newest domestic violence initiative has been the integrated domestic violence courts, which use one family, one judge, allowing a single judge to hear related criminal, family, and matrimonial cases for families affected by domestic violence. Now, to my mind, the best measure, the very best measure of the necessity for and the success of these courts has been to date that they have heard nearly 200,000 cases of domestic violence in the state of New York. Now, that's a figure that astounds me. I don't know how it hits you. 200,000 cases of domestic violence in the state of New York. And these courts, hopefully, have helped to avoid catastrophic consequences for thousands upon thousands of litigants. We have not had another murder-suicide, I am very pleased to say. In concluding this segment on problem-solving courts, I'd be remiss if I neglected to mention and heartily applaud both our Deputy Chief Administrative Judge for Court Operations and Planning, Judy Harris-Kluger, and the Center, yes, and the Center for Court Innovation, our public-private research. Imagine we have a research and development arm in the New York State court system. Doesn't that make a tremendous amount of sense? Special thanks to the Center's director, Greg Berman, and while I'm at it, to Greg's predecessor, New York City's criminal justice coordinator, John Feinblatt. While the mission is to help improve court performance, that is the absolute goal of the Center for Court Innovation, the center actually is administered as a project of the Fund for the City of New York, which is a nonprofit operating foundation, and thereby it gives us the absolute best of both worlds. We get inside knowledge and we get outside perspective and funding. Hand in glove with any report on civil and criminal juries and criminal courts goes a very favorite subject of mine, and that's the subject of juries. Juries. Well, don't we all want to be jurors? Of course we do. Imagine citizens from all walks of life called from their homes and their work and their families and friends to sit in judgment on fellow human beings with often life-altering consequences. Just think, 1 in every 3 Americans is likely to be empaneled as a juror during his or her lifetime. In New York State, we call about 650,000 people for jury service, don't we, Norman? Every year, and we conduct more than 10,000 trials annually, jury trials annually. Pretty amazing, don't you agree? Small wonder, then, that the jury was of such great importance to our nation's founders, or that Thomas Jefferson referred to the jury system as the only anchor yet ever imagined by man by which a government can be held to the principles of its Constitution. Some years ago, the analogy of jury service to an anchor regrettably became a particularly accurate one in New York State, or maybe, on second thought, an analogy to albatross. Albatross would definitely have been a better word. A jury summons was likened to dreaded root canal surgery. Why? It's hard to remember that not all that long ago, because of statutory exemptions, automatic exemptions, doctors and lawyers, police and firefighters, people who made prosthetic devices, people who wore prosthetic devices, our list of potential jurors was sorely depleted, and our juries had to be drawn from what we called a permanent qualified list. Now, those poor souls were summoned to the courthouse like clockwork every 2 years for a minimum of 2 weeks' service. If they were on a criminal jury, they were automatically sequestered overnight in one of our grand New York hotels during deliberations. Thankfully today, I think most New Yorkers would prefer a jury summons to root canal surgery. And that's even acknowledging that there have been great gains made in root canal surgery. Every year, beginning in 1994, we've tackled new initiatives all aimed at achieving and maintaining 3 main goals: a jury system that truly represents the community, a jury system that treats jurors with courtesy and respect, a jury system that makes service as efficient as possible. The project has been a truly statewide effort in every way, and I am especially grateful here to the New York State Legislature for its elimination of all automatic exemptions, as well as the requirement of automatic sequestration. About 5 years ago, a totally different sort of initiative got underway, what we call the Jury Trial Project, a group of 50 judges experimenting in real trials with a variety of 21st century trial practices, like allowing jurors to take notes and submit written questions about evidence during trial, and providing deliberating jurors with a copy of the judge's charge, and encouraging attorneys to make brief statements at the outset of voir dire to make that entire process much more meaningful. Their efforts led to their recommendations that these practices be widely adopted throughout our court system, but to date they have not been. We continue to address areas requiring improvement, and for this I am most grateful to Chester Mount, our Director of Court Research and Technology, to the wonderful people who work with him, and of course to every single one of our terrific commissioners of jurors, our interface with the public, implementing the reforms, explaining policies and procedures, creating a most welcoming and respectful environment to the New Yorkers, for the New Yorkers who appear for jury service. I'd like to end on this high note on the subject of jury service, but I don't have that luxury because the subject and task of jury reform just remains far from complete. There is, of course, the human reality that things left untended have a way of slipping back, but I mean something much more than the challenges of new technology. What I really have in mind is that the subject of jury reform has caught on like wildfire all across the nation, and there is a great deal more that we have to learn from one another. Most recently, the American Bar Association updated its jury standards, which reflects a whole new universe of research and experience. Indeed, the group of 50 wonderful New York judges I mentioned earlier, who tried out some of these new ideas, urged that we adopt the ABA recommendations, many of them in New York. We need to do that. The fact is that apart from anchoring us to our constitutional principles, the prized American jury system is a rare opportunity for the courts to show the public firsthand a justice system that is modern and up-to-date and effective and efficient, and we simply have to do more to seize that opportunity. And again, I hope you all agree. You do, don't you, prospective jurors? Yeah. I turn next to a few special initiatives resulting from the work of our commissions and committees and task forces. I'm sure you've all heard of them. I've conscripted so many of you to be shamelessly, don't you think so, asked you to volunteer your time to chair and serve on these groups. We always pick the very, very best people. And you know, without exception, they accept the invitation because they know when we ask that the subject is a serious one and the intention is to implement their sound recommendations. From all their work, you know, we never could have afforded to pay for their work, and the court system has consistently reaped huge benefits at very little cost. Today I'm going to highlight just two of the efforts that represent unfinished business, and I'm going to begin with the Special Commission on the Future of New York State Courts chaired by Kaye entitled Justice Most Local, the Future of Town and Village Courts in New York State. I'm sure you've all been reading and hearing a great deal about the town and village justice courts. We have 1,277 town and village justice courts throughout the state of New York. They play a key role in the state's system of justice. They hear more than 2 million cases. This is in addition to the 4 million we hear in the New York State court system. Traffic infractions, parking violations, misdemeanors, arraignments, preliminary hearings, and felony cases, small civil claims, landlord-tenant matters. Now, these courts collect more than $200 million in fees and fines, which are shared by the localities and the states. They are the only New York trial courts that are funded and administered by local governments, not by the state at all, not by us. And I might say therein lies a serious problem. As we have come to recognize, the quality of these courts varies greatly. Some of them are absolutely exemplary, others woefully short of acceptable standards. So 2 years ago, we began implementing an aggressive action plan to give assistance to these courts, to educate the judges. More than 60% of them are not lawyers. A requirement that justice court proceedings be recorded, a provision of digital recording devices and other modern technology at state expense to these courts. These steps unquestionably have made a vast improvement, but they're only the first installment in our commitment to upgrade these courts, so we especially welcome the offer of the Special Commission to study and report on these courts. And I urge you all to take a look at the report. They gave us an excellent report. You don't even have to go beyond the cover. Take a look at the cover, pinpointing the location of every single one of these 1,277 courts. It speaks volumes about one of the central recommendations. There is an entirely unnecessary proliferation of facilities, and they are expensive. So today, especially today, this is a subject that not only deserves but also demands immediate attention. The Commission proposes legislative appointment of a group to recommend consolidation of these courts and a vast, vast reduction in expense. It makes sense to me, however, that before the legislature takes that step, that the subject might first profitably be explored on a volunteer basis, and apparently there is some willingness to do so. I think all of the Commission's recommendations could promote efficiency, bring about significant savings, and clearly this is a very important bit of unfinished business for my successor, Chief Judge. And I move on ever so briefly to the recommendations of the Task Force on the Future of Probation in New York State to improve one of the most vital components of our criminal justice system, and that is our probation system. And here again, our outstanding chair, John Dunn, sought my permission, happily granted, to continue the work focused on the role in family court of probation. The recommendations, again, are set forth in a wonderful report, which we are releasing today. So you want to be sure you get that. And again, it's a wonderful roadmap for the future. It offers numerous recommendations to improve outcomes for young people, as well as proposals to improve probation's role with regard to victims and restorative justice. I believe that the court system, as well as Governor Patterson's task force on transforming juvenile justice, might well build on the recommendations of this task force, and I thank them for their comprehensive study. But before turning to my next subject, I pause here to thank every single one of our exceptional commissions that have, throughout my tenure, facilitated so many remarkable court system reforms, whether matrimonial rules or measures relating to the legal profession or fiduciary appointments or initiatives relating to judicial elections or juries or procedures for placing court records on the Internet. And I thank as well the groups that have pointed the way to resolve some very significant unfinished business. And here I look at Jonathan Gradess, and I put right at the top of my list the recommendations regarding the indigent defense, establishing a statewide indigent defense program. I think, too, of the Commission on the Future of the Courts, which recommended addressing the archaic and fragmented court structure, and the Probation Task Force, and our very newest initiative, significant unfinished business, a Commission on Interbranch Relations. And that brings me to an entirely new subject, court facilities and operations. And I begin with our courthouses, and I'm smiling. Clean, dignified, decent court facilities are important. They're important for jurors and judges and staff. Perhaps most of all, however, they are important for the litigants. It shows to the litigants that we respect them and we respect the matters that they bring to us. Now, in the early 1990s, we were using other D words. We weren't using decent and dignified court facilities. The New York State courthouses back then instead were dirty, they were dilapidated, they were deteriorated, and if you know other D words, I hope you will let me know. Responsibility for providing and cleaning the courthouses resided with local governments, and they just were not up to snuff. Fortunately, in the past 15 years, the situation has changed dramatically as we began working with the legislature and the State Dormitory Authority, and we are most grateful because in those years, can you believe this? More than 40 new courthouses have opened, and dozens have been renovated, expanded, and modernized all throughout the state of New York. We even have several projects underway, from a new city courthouse in Niagara Falls to the first new courthouse to be built in Staten Island in more than 60 years. I'm so pleased to say that progress is visible all across the state of New York, including the nation's 2 largest courthouse facilities located right here in New York City. Facilities, of course, represent a constant challenge. Older buildings deteriorate. All structures need maintenance and repair. I know that the court system will continue to work closely with our partners in government to ensure that every New Yorker has the facilities, the courthouse facilities, that they deserve for the conduct of their important business. And I'll single out just one facility for special mention, and that's the Judicial Institute. We call it the JI. Given the immense challenges today's society regularly deposits at the courthouse doors, we're fortunate to have a year-round center dedicated to judicial education and research. The JI opened in May 2003 in a brand new building on the campus of Pace Law School under the superb direction of Dean Robert Keating, and it has amply fulfilled our hopes, our ambitions. Thank you so much, Dean Keating. A special thank you to you. And now I'd like to turn to one really exciting new initiative we are announcing today regarding what goes on inside the courthouses, operations, and I call this green justice, and I think you'll all be excited to hear about this too. Today, we are releasing on our website the first ever comprehensive environmental plan for any justice system in the United States, in the world, in the universe. It's called Green Justice, an Environmental Action Plan for the New York State Judiciary. Pretty nifty, don't you agree? Yes. Now, I think we are exactly the right people to lead the way in this, because I've told you that we have millions of new case filings every single year. If you throw in the town and village justice courts, we're up to 6 million and more. Just think of the hundreds of millions of pages of paper we produce every year. Just think of the cost of the paper printed, manufactured, bought, sold, shipped, printed, duplicated, served, filed with the court, stored. Considerable energy, effort, and money at each and every step, to say nothing of the expensive trips we require lawyers and litigants to make to our courthouses. I'm sure many of you are painfully aware of this. Green Justice examines our justice system's environmental impact, from court procedure to regulation of the profession, from procurement to court facilities, from direct impacts on court operations to indirect effects on other branches and levels of government. Green Justice seeks to achieve more cost-effective and environmentally sustainable court operations. And this initiative, I assure you, will save dollars not only for the courts, but also for the litigants. And that's a perfect lead-in to my subject of technology, again under the subject of court operations. I am pleased to tell you that the New York State court system has solidly arrived in the 21st century with computer-related technology in every corner of our operations and increasing use of the Internet to improve service to litigants and to lawyers and to the public. Our court website is consistently named one of the top 10 websites in the nation, the world, the universe, with a vast and ever-expanding array of information on the courts, sections geared to litigants, attorneys, jurors, one for and about judges, even an area on court career opportunities, which I will be exploring. While in a sense everything I've just described has the objective of improving the operation of the courts and thereby building trust and confidence, I've reserved for this final portion of my report two subjects vitally connected to us in a different way. The first is access to justice. The second and last, you should be delighted to hear, is just a word about the legal profession. Now, many of our nation's courthouses are inscribed with the words, equal justice for all. That is the American ideal, isn't it? A government of laws, not men, applied equally no matter what the person's background or station. But for so many members of the public, those words ring hollow because they can't afford a lawyer to help them understand and enforce their rights. And this remains a tremendous challenge to make a reality of that promise. The Administrative Board resolved years ago to encourage lawyers to perform free legal service. The Continuing Legal Education Board amended the rules to allow credit, and our efforts since September 11 have been selflessly directed to sustaining the marvelous volunteer spirit of the New York Bar. But obviously, given the limited availability of free legal services, large numbers of civil litigants have to navigate the courts without counsel. So we have worked hard to ease the way for them with offices for the self-represented, with legal forums and referrals and resource centers. This, again, remains a tremendous job ahead, and I thank our Deputy Chief Administrative Judge Juanita Newton here for spearheading so many of our efforts. I've saved for last just a word or two about our extraordinary bar, boundless words of commendation. The courts and the great lawyers and bar associations of the state of New York, we are joined at the head and the heart. The bar is utterly essential to every single thing that goes on in the courts. Obviously, our biggest user, the bar, has been also our biggest supporter. And yes, perhaps every now and then there's been a word of disagreement between us over the past 15 years, but we've taken every single thing to heart, and we have addressed them together, all the disagreements together and splendidly. The lawyers of this state have been unstinting in their contributions to all of our work, our special projects, our advisory committees, our education outreach programs, and these are just a few examples of our valued partnership. I'd mention but one significant project that is on the agenda of the Administrative Board now, and that is the effort initiated by the New York State Bar Association to transition from the age-old Model Code of Professional Responsibility to a New York form of the Model Rules of Professional Conduct promulgated by the American Bar Association. As of this date, I am pleased to say I am very, very, very hopeful that before December 31, 2008, this indeed will be accomplished. And now I reach two of the most beautiful words in the English language, in conclusion. And I think that this report establishes two conclusions beyond a shadow of a doubt. First, having listened to my swan song, my final State of the Judiciary, you all know most definitely that I am not the mute swan. And second, I have read and agree that the sense of ending that is captured by the phrase swan song is invariably poignant and heartrending, and I surely do feel that to the very depths of my soul. Again, there can be no doubt that I have had the role of a lifetime, a privilege beyond description to labor in the cause of justice alongside the greatest people on earth, beginning with my colleagues and court staff in my second full-time job as Chief Judge of the Court of Appeals, the presiding justices, all of the judges, administrative supervising judges, and the exemplary staff of the unified court system, and particularly my counsel, Mary Moan, and my chamber staff, the great bar of the state of New York, and our innumerable partners in and outside of government. And here I single out for special words of praise and gratitude my dear friend, ally, partner for more than a dozen years, in every single one of the ventures I've outlined today, Jonathan Lippman, a great, great Chief Administrative Judge. As well as his great, great predecessor, Leo Malonis, and his great, great successor, Ann Fow. How fortunate I have been to have had their wise counsel and tireless dedication and unfailing friendship through unimaginable personal and professional joy, tragedy, and everything in between. Now I prepare to assume my next title, New York's first female former Chief Judge. And as I do so, it seems to me that the judiciary I leave behind, while in one key regard deeply pained personally and individually, that judiciary has heroically risen to its obligation to serve the public wisely and diligently, soundly and innovatively, preserving and carrying forward the best of the past to meet the demands of a rapidly changing society. And every day the news reminds us that as dockets rise and pressures intensify, the courts must continue to be the good, responsible citizen we have been throughout, attentive always to budgeting leanly and transparently, and making careful use of our resources in every aspect of our operations. I know that the process in place to choose my successor, culminating in appointment by Governor David Paterson and confirmation by the Senate, will yield precisely the right person to lead the New York State court system into the future, and I pledge my full support in any way I can be helpful. Thank you so much. meeting is adjourned.